My esteemed colleagues on the bench, Mr. Ashok Parija, the Learned Advocate General, Mr. Dharnir Nayak, Learned President, and other office bearers of the Orissa High Court Bar Association, Mr. P.K. Padi, the Learned Deputy Solicitor General, Government of India for the High Court of Orissa, learned senior advocates and members of the legal fraternity, family members of Mr. Justice Ahmadi, present online, members of the registry, ladies and gentlemen. We have assembled today to condole the sad demise of Mr. Justice Aziz Mushabbar Ahmadi, former Chief Justice of India, who breathed his last on 2nd March 2023 at the age of 91 years. In the annals of judicial history, we have had judges who have made a significant contribution to the development of law and also to the judicial system as a whole. Justice Ahmadi belongs to that class of outstanding judges whose contributions will always be remembered. Justice Ahmadi was born on 25th March 1932 in the city of Surat under the then Bombay Presidency. He completed his education from Gujarat University, and after receiving his Bachelor of Laws degree, Justice Ahmadi joined the bar in 1954. He enrolled as an advocate in Bombay. He joined the judicial service and was appointed as a judge in Ahmedabad's City Civil and Sessions Court 10 years later in 1964. In 1974, Justice Ahmadi was appointed to the post of Secretary of the Gujarat government's legal department, which soon led to an appointment as judge of the Gujarat High Court in 1976. Justice Ahmadi took an active role in a number of advisory bodies during this period, including the Gujarat State Third Pay Commission. As judge of the Gujarat High Court, Justice Ahmadi worked as chairman of various advisory boards, and a few of them were the Conservation of Foreign Exchange and Prevention of Smuggling Activities Board, the Prevention of Black Marketing, the Maintenance of Supplies and Essential Commodities Board, etc. Justice Ahmadi was elevated as a judge of the Supreme Court of India in December 1988. During his tenure as a judge of the Supreme Court, he held the positions of the President of the Supreme Court Legal Aid Committee and Executive Chairman of the Committee for Implementation of Legal Aid Schemes in India. Justice Ahmadi was appointed as the 26th Chief Justice of India on 25th October 1994 and held that position until his retirement on March 24th, 1997. He had an exceptional career, handling the judicial process at all three levels of the judiciary, apart from being the Chief Justice of India for about 3 years, out of his total term as a judge in the Supreme Court for about 9 years. Justice Ahmadi made significant contributions to the development of the law. Although there are numerous instances to illustrate this, among the most significant ones that had a vital impact on sentencing in criminal cases was his decision in Alauddin Mian versus State of Bihar in 1989. This was regarding the necessity of a trial court while sentencing a person convicted for the offense under Section 302 IPC to postpone to a separate date the question of sentence. The relevant provisions were Section 235, subsection 2, read with Section 354, subsection 3 of the CRPC. Justice Ahmadi presciently observed, in his opinion, Section 302 IPC casts a heavy duty on the court to choose between death and imprisonment for life. When the court is called upon to choose between the convict's cry, "I want to live," and the prosecutor's demand, "he deserves to die," it goes without saying that the court must show a high degree of concern and sensitivity in the choice of sentence. In our justice delivery system, several difficult decisions are left to the presiding officers, sometimes without providing the scales or the weights for the same, to give a separate hearing on the question of sentence at a postponed date. Justice Ahmadi went on to hold, and I quote, "In a case of life or death, as stated earlier, the presiding officer must show a high degree of concern for the statutory right of the accused and should not treat it as a mere formality to be crossed before making the choice of sentence. If the choice is made, as in this case, without giving the accused an effective and real opportunity to place his antecedents, social and economic background, mitigating and extenuating circumstances before the court's decision on the sentence would be vulnerable. We need hardly mention that in many cases, a sentencing decision has far more serious consequences on the offender and his family than in the case of a purely administrative decision. A fortiori, therefore, the principle of fair play must apply with greater vigor in the case of the former than the latter. An administrative decision having civil consequences is taken without giving a hearing is generally struck down as violative of the rule of natural justice. Likewise, a sentencing decision taken without following the requirements of subsection 2 of section 235 of the Code in letter and spirit would also meet a similar fate and may have to be replaced by an appropriate order. The sentencing court must approach the question seriously and must endeavor to see that all the relevant facts and circumstances bearing on the question of sentence are brought on record. Only after giving due weight to the mitigating as well as the aggravating circumstances placed before it, it must pronounce the sentence. We think, as a general rule, trial courts should, after recording the conviction, adjourn the matter to a future date and call upon both the prosecution as well as the defense to place the relevant material bearing the question of sentence before it, and thereafter pronounce the sentence to be imposed on the offender. Unquote. In Dr. M. Ismail Faruqi versus Union of India in 1994, a constitution bench of which Justice Ahmadi was part was deciding both the validity of the acquisition of certain areas at Ayodhya Act 1993 as well as the maintainability of the presidential reference under Article 143, Subarticle 1 of the Constitution of India. Although the majority comprising the Chief Justice Venkatachalaya, Justice Verma, Justice G.N. Ray, as well as the minority opinion of Justice Ahmadi and Justice Bharucha, agreed that the presidential reference must be returned unanswered, the minority dissented on the issue of the validity of the act and struck it down. The minority opinion, joined in by Justice Ahmadi, observed, and I quote, "The preamble to the Constitution of India proclaims that India is a secular democratic republic. Article 15 in Part 3 of the Constitution, which provides for fundamental rights, debars the state from discriminating against any citizen on the ground of religion. Secularism is given pride of place in the Constitution. The object is to preserve and protect all religions, to place all religious communities on par. When, therefore, adherents of the religion of majority of Indian citizens makes a claim upon and assails the place of worship of another religion by dint of numbers, creates conditions that are conducive to public disorder, it is the constitutional obligation of the state to protect that place of worship and to preserve public order, using for the purpose such means and force of law and order as are required. It is impermissible under the provisions of the Constitution for the state to acquire that place of worship to preserve public order. To condone the acquisition of a place of worship in such circumstances is to efface the principle of secularism from the Constitution." Further, the minority observed, "Hinduism is a tolerant faith. It is that tolerance that has enabled Islam, Christianity, Zoroastrianism, Judaism, Buddhism, Jainism, and Sikhism to find shelter and support upon this land. We have no doubt that the moderate Hindu has little taste for the tearing down of the place of worship of another to replace it with a temple. It is our fervent hope that the moderate opinion shall find general expression and that communal brotherhood shall bring to the dispute at Ayodhya an amicable solution long before the courts resolve it." And then they quoted Mahatma Gandhi, "India cannot cease to be one nation because people belonging to different religions live in it." Justice Ahmadi was in the Constitution bench of 9 judges, which heard the second judge's appointment case in 1993. According to Justice Ahmadi, who was in the minority, the majority, and I quote, "follows a path leading to a destination unknown to the Constitution." In the case of S.R. Romai versus Union of India, the bench comprising Justice Ahmadi and other judges was required to determine the scope of the powers of the president under Article 356 of the Constitution. The bench, which included Justice Ahmadi, found that the president's power in this regard was not absolute and that the president could not act unless the proclamation was approved by both houses of parliament. The court also ruled that the power of the president under Article 356 was subject to judicial review only on limited grounds. They rendered a separate judgment and concurred with the majority and held that the extraordinary power under Article 356 of the Constitution is to be exercised duly under utmost circumspection and in exceptional cases. In L. Chandrakumar versus Union of India, Justice Ahmadi authored the judgment of the Constitution bench that held that the creation of tribunals under Article 323A and 323B does not result in the exclusion of the jurisdiction of either the Supreme Court or the High Courts under Articles 32, 226, and 227 respectively. This decision was based on the finding that the jurisdiction conferred upon the Supreme Court under Article 32 and the High Courts under Articles 226 and 227 form part of the basic structure of the Constitution and were inviolable. In doing so, the bench struck down Clause 2D of Article 323A and Clause 3D of Article 323B and declared them to be unconstitutional. In fact, the Chandrakumar judgment has again been reiterated very recently by the Supreme Court of India in ordering that orders of the Armed Forces Tribunal should be first tested in a division bench of the High Court. Justice Ahmadi was an able administrator, and this was reflected in many of the initiatives launched by him after he reached the Supreme Court. The foremost was the computerized cost list and the formal and extensive use of computers in the routine functions of the court. This included making available digital copies of orders and judgments. He also laid emphasis on the scientific manner of classification and categorization of cases. His caseload distribution technique was also noteworthy. Having served at all levels of the judiciary, he could have a holistic vision of the judicial system and understood what is practicable and workable. Another move was the formal introduction of the system of judicial clerkship in the Indian Supreme Court. A product of the National Law School in Bangalore, Arun Thiruvengadam, now a law professor, was Justice Ahmadi's first law clerk. Apparently, when Arun would explain to Justice Ahmadi that a case involved an interesting question of law, Justice Ahmadi would insist on knowing what the real relief claimed was. It was striking that Justice Ahmadi often foregrounded the possibility of the judicial order being passed capable of execution. Justice Ahmadi was invited by various international organizations, including the UN, the World Bank, to lead special projects. He was the recipient of honors from highly reputed legal institutions, such as the American Inn of Laws, the Middle Temple of the Honorable Society in London. Apart from receiving the degree of Doctor of Laws, honoris causa, from 6 of the most reputed Indian universities, he was also Chancellor of the Aligarh Muslim University. He was nominated on international committees which looked into human rights violations in East Timor and also to review the state of the relations between judiciary, the legal profession, and the executive in Zimbabwe. He undertook several lecture tours within and outside the country. One of his later law clerks, Ashutosh Rai, wrote an obituary recently in Bar and Bench where he reminisced, and I quote, "He encouraged young advocates to appear before him and gave them a patient hearing and constructive feedback regularly. Despite having held high offices, he would always treat his law clerks and legal assistants as equals. He would often introduce them as my colleague and my associate, a term not used as often by senior members of the legal fraternity." Rai also writes that Justice Ahmadi loved shares and would always have at least one handy for any situation. One of his favorites was the following one by Dr. Iqbal. खुदी को कर बुलंद इतना के हर तकदीर से पहले खुदा बंदे से खुद पूछे बता तेरी रजा क्या है. It translates roughly as elevate yourself to the extent that before every destiny, God should himself ask you as to what you desire. Justice Ahmadi received many honors and recognitions during his lifetime. He was also offered the degree of Doctor of Laws conferred by the University of Leicester, England. The demise of Justice Ahmadi is a great loss, not only to his family and friends, but to the Indian judiciary as a whole. His life and work are an inspiration to the succeeding generations of lawyers and judges. Justice Ahmadi was deeply attached to his wife, who predeceased him by just 6 months. He is survived by his son, Mr. Huzaifa Ahmadi, a senior advocate in the Supreme Court of India, daughter, Miss Tasneem Ahmadi, a practicing lawyer in the Supreme Court of India, daughter-in-law, Miss Insia Ahmadi, grandson, Mr. Ali Asghar Ahmadi, and granddaughter, Miss Insia Vanvati. On behalf of my sister and brother judges, and on my own behalf, I express our heartfelt condolences to the members of the bereaved family and pray that the departed noble soul of Justice Ahmadi rests in peace. We also pray for the strength and courage to the members of his family to bear the irreparable loss.
My Lord, Honorable the Chief Justice, my Lord's companion judges, members of the registry, the Deputy Solicitor General of India, Sri Padi, President, Vice President, Secretary of the High Court Bar Association, family members of Justice Ahmadi present with us today, respected senior members of the bar, and my junior colleagues. On behalf of the state and my colleagues, I convey our deepest condolence on the sad demise of Honorable Justice A. Ahmadi, former Chief Justice of the Honorable Supreme Court of India. Late Justice Ahmadi was born on 25th of March 1932 in Surat, at that point a part of Bombay Presidency in British India. After obtaining his law degree, he enrolled as an advocate at Bombay in the year 1954 as a district attorney. Within a short span of 10 years, he was appointed as the district judge in Ahmedabad. Subsequently, he became the Secretary of Law Department, Government of Gujarat in 1974. Soon after, he was elevated to the bench on 2nd of September 1976 at the Gujarat High Court. During this time, as a judge of the High Court, he served as a member of several advisory boards, such as the Advisory Board under Conservation of Foreign Exchange and Prevention of Smuggling Activities 1974, the Gujarat State Third Pay Commission, etc. Justice Ahmadi's illustrious career reached its crescent when he was elevated to the Honorable Supreme Court in December 1988. He succeeded Justice M. N. Venkatachalaya as the 26th Chief Justice of India on 25/10/1994 and served as Chief Justice of India for 3 years till his retirement on 24th of March 1997. During his tenure on the bench at the Supreme Court, Justice Ahmadi presided over crucial cases and authored landmark judgments that defined constitutional interpretation. He was a part of the bench constituting of 9 judges in Indira Sani case. In Mafatlal case, Justice Ahmadi held that a party cannot claim relief, which would lead to unjust enrichment, and many more judgments. During his illustrious 9-year tenure in the Supreme Court, Justice Ahmadi authored 232 judgments and was a part of 811 benches. Post-retirement, Justice Ahmadi served as the Chancellor of the Aligarh Muslim University from 2003 to 2010, a champion of human rights. He had, at the behest of United Nations, International Court of Justice, World Bank, and International Bar Association's Human Rights Institute, led several delegations and missions to East Timor, Liberia, Bangladesh, and Zimbabwe, respectively. Late Justice Ahmadi will be fondly remembered as a sharp judge who interprets law with empathy and special concern for the voiceless. He was always polite yet firm to the bar and knowledgeable in all branches of law. He was known to be deeply devoted to his late wife, whom he described as his pillar. He is survived by his son, senior advocate Faiza Ahmadi, and daughter Tanseem Ahmadi, also an advocate, who are present with us this afternoon by virtual mode. My Lord, may his soul rest in eternal peace.
My Lord, the Honorable Chief Justice and Honorable Judges, Honorable Advocate General of the State, Honorable Deputy Solicitor General of India for High Court of Orissa, Honorable Government Advocates, officers of the Advocate General Office, officers from the Registry, the Vice President, Secretary, Joint Secretary, Assistant Secretary, and other office bearers of the High Court Bar Association, Honorable senior members, honorable members of the bar. With profound grief, I express my heartfelt condolence on the sad demise of late A. Ahmadi, former Chief Justice of the Supreme Court of India. Former Chief Justice of India, A. Ahmadi, was born on March 25th, 1932 in Surat, State, Gujarat. Justice Ahmadi served as the Chief Justice of India from 25th October till 1994 till his retirement on 24th March 1997. His judicial career as a city, civil, and sessions judge in Ahmedabad, he was the only Chief Justice of India who started at the very lowest rank to rise to the highest position of the Indian judiciary. Justice Ahmadi was felicitated jurist not only in India but also across the world. He was invited by various international organizations, including UNO and World Bank, to lead special projects. He was the recipient of honors from the highly reputable legal institutions such as American Inn and Law of Middle Temples in Honorable Society of the Middle Temple, London. Apart from receiving the degrees of Doctorate of Laws honoris causa from 6 of the most reputed Indian universities, he was the author of numerous path-breaking judgments. His expertise was wide-ranging, from constitutional law to human rights, freedom of speech, criminal taxation, center, state, and interstate relations. He was also the Chancellor of Aligarh Muslim University. Apart from being one of the longest service Chief Justice of India, he also shouldered the responsibility of heading various commissions and was contributing actively in the field of arbitration till the end of his life. He passed away on 2nd March 2023 at the age of 90. May his soul rest in peace. My Lord,
Yeah. May I request that we all stand 2 minutes in silence, please.